Dear students, viewers, and the subscribers, welcome to the IAS Mentor. You are watching the series Indian Polity, and we are in lecture number 89 in the series Indian Polity. As I already told, this series is going to be one of the most useful series to the students preparing for UPSC as well as other competitive examination, especially when it comes to the subject Indian Polity. The very objective of this series is to provide a comprehensive idea on this particular subject. And we have covered a number of topics. So presently we are looking into the topic of the state legislature. And most of the things that you are going to discuss in the state legislature has been already discussed as a part of the parliament. That is the union legislature. Mostly it is the same, but however there may be few differences. So therefore the students who are looking into this particular lecture try to understand wherever there is a difference. If you already watched the parliament chapter, it is going to be very easy. But even the students who are coming directly to this particular lecture, they should also not to be in any disadvantaged position. For that reason, I am again explaining all the things with regard to what is called as a state legislature. In today's lecture, we are going to understand the topic of what is called as the sessions in the state legislature. So we'll understand as to what is a session, what is termination of a session, what is dissolution of the houses, who is supposed to do that, what will happen to the bills during the dissolution of the house, and of course we will also touch upon the topic of what is called as privileges to the members of the state legislature, as we have seen in case of the members of the parliament. So all those things will be covered in the today's lecture. So we'll just directly get into the topic and we'll try to understand as to what is the sessions in the state legislature. Now, what the constitution says with regard to the sessions in the state legislature, the only provision that is given in the constitution with regard to the sessions in the state legislature is that there shall not be a lapse of more than 6 months between two consecutive sessions. That's the only thing. And apart from that, the constitution says who is supposed to summon the sessions in the state legislature. It is the governor who is supposed to summon the sessions in the state legislature. However, this is not a discretionary power of the governor. The governor is supposed to do that based on the aid and advice of the Council of Ministers. Okay, before we proceed further and we understand all those things, we'll have to understand what does it mean by a session. So to make you understand better, say for example, many times you have heard in the news something which is called as the budget session, and then there is something which is called as monsoon session, and then winter session. These are the words repeatedly you might have heard in the news. Now these are all nothing but different occasions on which the parliament meets, or the members of the parliament as a collective body they meet. So this is basically what is called as a session. And in every session in the parliament or in the respective houses, Lok Sabha will have its session, Rajya Sabha also will have its session. Every session, the members of the parliament and the government wanted to transact certain business in the house, be it enacting the budget, be it enacting the bills, be it introducing any of the motions. So all those business will be transacted. When they will be transacted, all these business will happen or it will be transacted during the sessions. And after the session is over, then the parliamentarians will not go to the parliament. And again, a new session will be summoned. So what is the purpose of summoning a session? The purpose of summoning a session means, in case of the parliament I am talking, that the president is calling upon the members of the parliament to come and to start the business of the house. And once they will complete the business for that particular session, the session will be terminated. That is basically what is called as prorogation of the session. Now similarly, as it happens in the parliament, the same thing is likely to happen in the state legislature as well, because both at the union level as well as at the state level we have got is parliamentary democracy. So therefore, who is supposed to summon the sessions in the state legislature? It is the responsibility of the governor to summon the sessions in the state legislature. So you just replace with whatever you learned in case of the parliament. Wherever you use the word president, here we will replace it with what is called as a governor. So therefore, who is supposed to summon the sessions of the state legislature? It is a governor. In any state, if there is a legislative assembly as well as legislative council, the sessions in both the houses shall be summoned by the governor. But however, try to understand, not both the houses, the sessions may start at the same time and it may end at the same time. Both the houses can function independently. But however, in both the houses, who is going to summon the session? The governor is going to summon the session. Now, but however, as I already said, this is not the discretionary power of the governor. The governor does it based on the aid and advice of the Council of Ministers. So therefore, there is nothing that is given in the constitution as to how many sessions has to be there in a given year in the state legislature. What shall be the duration of the session? What is the minimum number of days that the members of the state legislatures have to meet? None of these information is given in the constitution. The only information that is given in the constitution is that the governor shall summon the session, the governor shall prorogue the session. The only information apart from this you'll have to remember is that the time gap between two sessions shall not be more than 6 months, or the recess in the state legislature shall not be more than a period of 6 months. So how this is to be calculated? I'll let you know how this can be calculated. But first and foremost thing that you'll have to understand is, first, what is summoning of a session? So summoning of a session means that basically it is what is called as calling upon the members of the state legislature to start a session. So start of a session or starting a session is what is called as summoning. Okay. Before even understand that, I have told that it is budget session, monsoon session and winter session. Today in the parliament, as a parliamentary conventional practice, it is merely a conventional practice that there are 3 sessions which is summoned by the president. But not necessarily always there may be 3 sessions. It can be 2 sessions also, it can be 4 sessions also. Because all that the president has to make sure is that there shall be a lapse of more than 6 months between 2 consecutive sessions. But how many sessions is not prescribed in the constitution. Similarly, in the state legislature also, how many sessions are not prescribed. But most of the state legislature, they also follow the same convention that is followed in the parliament. So the state legislatures may also have 3 sessions. But however, as I already said, it is merely a conventional practice. Nothing is mentioned in the constitution. So you have to be very, very clear about that. Okay, so once you know that it is only a parliamentary conventional practice, now what does it mean by summon? Summoning means the governor is calling upon the members of the state legislature to start a session. Suppose let us assume this is the start of the session. So I'll put it session 1 and this is the starting point. And then once the session starts, many business will be transacted. And at one point of time, they have come to the end of the session. Session 1, this is the end point. So what will happen is, once the session is summoned by the governor, then the members of the state legislature or the members of the legislative council in the respective houses, they will transact the business. And once they have completed all the business, then at one point of time, the governor of that particular state will also prorogue the session. Prorogue means this is also, end is also what is called as termination of the session. That means whatever is a business that is to be done, that is all over. So therefore, there is no need for the session. So once the session is terminated, then there is nothing but there is no meeting in the state legislature. That is basically what is called as lapse, or it is also what is called as recess. Okay, the appropriate word is not lapse. I'll just taking it back. So the appropriate word was what is called as recess in the state legislature. Recess means that the houses does not meet and the MLAs or the MLCs, they do not perform any function. And one more thing that you'll have to keep in your mind, as I already said, it is not necessary that the both the houses will come to session at the same time and both the houses will, the prorogation or the termination of the session will happen at the same time. It may happen at different time also, but there should be a summoning, and once there is a summoning, there is a prorogation, that is termination of a session. So session 1 is starting at this point, it is ending at this pointing. Starting is basically what is called as summon and end point is basically what is called as prorogation. So prorogation is basically what is called as termination of a session. And who is supposed to terminate a session? That is also to be done by the governor on the aid and advice of the Council of Ministers. Now in this way, that starting of a session, ending of a session, again after some time, the governor may summon what is called as session 2. So there will be a starting point to the session 2 and there may be an end point to session 2. The gap between the termination of session 1 and the summoning of session 2 is basically what is called as recess. That means during that point of time, when we called it as recess, the state legislature was not in session, or a particular house in the state legislature was not in session. So therefore, that is what is recess. The only thing that the governor has to keep in mind is the recess shall not be more than a period of 6 months. The recess time should always be less than 6 months or maximum 6 months. That means once a session is terminated, within 6 months, the new session has to be summoned. This is the only thing that the governor has to keep in mind as to how he will exercise his powers and functions, but nothing more than that is prescribed in the constitution. Okay, we know what is summoning, we know what is termination, and we also know that the recess in the houses shall not be more than 6 months. In this way, there will be starting of a session, termination of a session, again starting of a new session, termination of a session, again a starting of a new session, termination of a session. In this way, this cycle is likely to continue for 5 years, because what is the term of the Legislative Assembly? The term of the Legislative Assembly is 5 years. And when the term of the Legislative Assembly is over, when the 5-year time is over, then the House itself will be dissolved. And that is basically what is called as dissolution. So when I talk of dissolution, the dissolution can happen only in what is called as a Legislative Assembly. So the House itself will be dissolved. The Legislative Assembly will be dissolved. And whose power is to dissolve the Legislative Assembly? It is the power of the governor again to dissolve the Legislative Assembly. And when normally the Legislative Assembly is dissolved? At the end of the 5th year, that is the end of the term of the Legislative Assembly. But can it be dissolved earlier also? Yes, there are certain circumstances under which the Legislative Assembly can be dissolved earlier also. And what is the circumstances under which it can be dissolved earlier? It can be dissolved earlier provided there is a no confidence motion against the government. So that is the circumstances under which it can be dissolved earlier. So these are all the things that you'll have to keep in your mind as to what is summoning, what is prorogation, and what is dissolution. And the recess shall not be more than a period of 6 months. This is the only thing that the governor has to keep in his mind. But basically it is not the governor, because the governor does it based on the aid and advice of the Council of Ministers. So we know what is summoning, we know what is prorogation, we know what is dissolution, we also know what is recess. But in the process, we shall also understand as to what is adjournment and what is adjournment sine. While summoning, prorogation, dissolution, everything is done by the governor. But whereas adjournment and adjournment sine is done by what is called as a presiding officer. So who is capable of exercising adjournment and adjournment sine within the sessions? Both the things happens within a session. In every session there can be adjournments. In every session there will be adjournment sine. And who is supposed to exercise adjournment and adjournment sine? It will be done by the presiding officers of the respective house. So for example, adjournment and adjournment sine in the Legislative Assembly is done by the Speaker of the House. Adjournment and adjournment sine in the Legislative Council is done by the chairman of that particular house. So therefore, what is adjournment and what is adjournment sine? So what is adjournment? Adjournment is only what is called as a temporary break in that particular session. So any temporary break, but it is a definite break. Now say for example, let us assume in your school or in your colleges, let us assume there is a break after every midterm. So for example, in most of the schools they follow quarterly exam and then half yearly exam and then annual exam. So first from the starting date till the quarterly exam, let us assume that is session 1. From after that quarterly exam is over, there is some break. So let us assume that is recess. And then again after the exam results are announced, the school begins. So let it is session 2. And then half yearly exam is over, then there is a break. Let us assume that is recess. And then the third term begins. So in this way, let us assume these are all different sessions. But even at the starting of the school until your quarterly exam is over, or in the colleges there can be a midterm exam, whatever it is, let us assume the starting of the college until the midterm exam comes, let us assume that is session 1. But within that particular session there are holidays. Say for example, there is a Sunday, there are festival holidays, there can be exam leaves, whatever it is. But we know when to meet again, because we know that is only 1 day leave or 2 day leave, but again we will meet, but it is still the first term. So that definite breaks within a session is what is called as adjournment. So similarly in the state legislature also, the presiding officer can give breaks. So for example, the break can be very small breaks also. It can be a break for hours, it can be a break for days, it can be a break for weeks, but these are all definite breaks, which means the members know when to meet again. So this is basically what is called as adjournment. So for example, the house is adjourned for the lack of quorum, the house is adjourned for the lunch break, whatever it is, these are all what is called as definite breaks. So they know when to meet again within a session. And then there is something which is called as adjournment sine die. What do you understand by adjournment sine die? Adjournment sine die means, suppose let us assume that the presiding officer gives a break, but that is an indefinite break. That means the presiding officer gives a break to the members in the house, but he does not say when to meet again. And when normally the presiding officer will give this break, the presiding officer will give this break once the members in the house have completed all their functions. They completed all their functions and there is no more function to do. At that point of time, the presiding officer gives what is called as adjournment sine die. So this is basically what you'll have to understand with regard to adjournment sine die. So normally whatever is the business that is to be done, once all the business is over and after the business is completed, because the presiding officer does not have the power to prorogue the session, it is only the governor who can prorogue the session. The presiding officer will pass what is called as adjournment sine die. Usually this happens at this stage. At this point, when all the business in the house is over, but the presiding officer has no power to prorogue the session, so therefore he issues what is called as adjournment sine die, which is basically an indefinite break. So definite break means who will do it? It will be done by the presiding officer. Sorry, adjournment and adjournment sine die both will be done by the presiding officer. But whereas on the contrary, summoning, prorogation, dissolution will be done by what is called as the governor of the concerned state. The only thing that the governor has to keep in mind is that the research should not be more than a period of what is called as 6 months. That's the only thing he has to keep in his mind. Now at the end of the 5 year, what happens is what is called as a dissolution of the legislative assembly. And who will dissolve the legislative assembly? Again, the governor will dissolve the legislative assembly. But what will happen to the legislative council? Can the legislative council be dissolved? The legislative council cannot be dissolved because the legislative council is a permanent body similar to that of Rajya Sabha. And it is only to the legislative assembly and the legislative assembly, and same is in the case of Lok Sabha, they can be dissolved after 5 years and then the election happens. Now the next question is, what will happen to all the pending proposals, especially the bills in the state legislature when the legislative assembly is dissolved? Whenever the assembly is dissolved, there can be many proposals that is pending in that particular house or in the state legislature. What will happen to those proposals, especially the bills? The bills will continue from wherever they are, or the bills will lapse? So this is another thing that you have to understand. So we'll try to understand as to what will happen to the bills when the legislative assembly is dissolved. Now try to remember this as a general rule. Whenever the legislative assembly is dissolved, any proposal which has got any relation to Lok Sabha will lapse in the parliament. Now similarly, whenever the legislative assembly is dissolved, any bills or any proposal which has got relation to the legislative assembly will also lapse. In the Lok Sabha, any relation to Lok Sabha, on dissolution of Lok Sabha, the bills will lapse. So similarly, in case of the state legislature, if a bill has got any relation to the legislative assembly, on dissolution of legislative assembly, the bill is likely to lapse. This is a general rule. Now try to remember, this is a general rule. I am talking about the general rule, but there are few exceptions also. Okay, what is a general rule? The general rule is any bill which has got any relation to the legislative assembly. If there is a relation to the legislative assembly, on dissolution of the legislative assembly, the bills will lapse. So this is the general rule. But what are the cases the bill does not lapse? If the bill has no relation to the legislative assembly. If the bill does not have any relation to the legislative assembly in the first place, then the bill does not lapse. So therefore it is not going to lapse, because only when it has a relation to the legislative assembly, it is likely to lapse. In other cases, even let us assume the bill has a relation to the legislative assembly. Even if the bill has a relationship with the legislative assembly, but if the governor is already involved in the process, then the bill is not likely to lapse, or the bill will not lapse. That's what basically we'll have to understand. So when it is likely to lapse? A bill which has got any relation to legislative assembly, on dissolution of legislative assembly, it is likely to lapse. If the bill has no relation to the legislative assembly yet, that is, the bill is introduced only in the legislative council and it is pending in the council, and in the meantime the legislative assembly is dissolved, then the bill will not lapse. But if it has got any relation to the legislative assembly, the bill is likely to lapse. Or even it may have a relation to the legislative assembly, but if the governor is involved in the process, then the bill is not likely to lapse. So with that, just try to understand as to, if you remember this rule, that itself is sufficient, but what are the possible permutation and combination? A bill pending in the legislative assembly. There are two circumstances when the bill is pending in the legislative assembly. The first case is the bill is introduced in the legislative assembly, and while the bill is in the legislative assembly is dissolved. The bill will lapse. or the bill is introduced in the legislative council, passed by the legislative council, come to the legislative assembly, and when the bill is in the legislative assembly is dissolved, then also it will lapse. Both the condition, bills pending in the legislative assembly. All bills pending in the assembly passed by the council. So in this case, the bill is introduced in the council, from the council it is passed and it has come to the assembly, then the assembly is dissolved. In this case also the bill will lapse. Now what are the circumstances it does not lapse? Try to understand. In both the cases, you can understand that it has got a relation to the legislative assembly. So therefore, on dissolution of legislative assembly, the bill will lapse. But however, I said what is the exception? Although it may have a relation to the legislative assembly, if the governor is involved in the process, the bill is not likely to lapse. So see the first condition, bill sent for reconsideration by the governor or the president. Bill sent for reconsideration by the governor or the president means that the bill has been sent to the governor and the governor is sending it for reconsideration. So though it have a relation to the legislative assembly, but the governor is already involved in the bill. So therefore the bill does not lapse. But why president? It is also because of the fact sometimes one of the option that can be exercised by the governor. What is one of the option that can be exercised by the governor? He may also reserve it for the consideration of the president. And once he reserves it for the consideration of the president, then also the governor is involved. And therefore then the president can exercise a number of options. But in this case also the bill is not likely to lapse. So this is one condition, it is unlikely to lapse. The second condition is the bill pending for the assent of the president or the governor. That means the bill has been sent to the governor and the governor is yet to take an action, maybe one case, or the governor has reserved it for the consideration of the president and the president is yet to take an action on this bill. In both the cases, the bill is not likely to lapse because the governor is already involved in the process. Or there is another occasion where the bill is pending in the council and not passed by the assembly. That is, the bill is introduced in the council, pending in the council, in the meantime the assembly is dissolved. This bill is yet to establish a relation with the assembly. So therefore this bill will also not lapse. So these are all the various circumstances you will have to keep in your mind under what circumstances the bill is likely to lapse and the bill is not likely to lapse. So what is very important, that if you remember all these permutation and commutation, you may make a mistake. I am not saying that you will end up making a mistake. But if you just remember the rule, you can apply that rule to any of the condition and then you can answer the question. So general rule, if a bill has got any relation to the legislative assembly, on dissolution of the assembly, the bill will lapse. So if it has no relation to the assembly, on dissolution of assembly, it will not lapse. It may have a relation to the assembly, but if still the governor is involved in the bill, in the process, then the bill is not likely to lapse. So this is what you have to remember. So therefore you can get the correct answer. Now before I complete this particular lecture, I wanted to discuss another important topic, that is parliamentary privilege. But it is merely a repetition of what I have already done in the parliament chapter. It is merely a repetition of what are the privileges that is exercised by the members of the parliament. The only difference is, in case of members of parliament, their privileges comes from article 105 of the constitution. So this is for the MPs, and it is article 194 which provides the privileges to the members of the state legislature. For the members of the state legislature, it does come from article 194 of the constitution. So this is basically what you'll have to keep in your mind. But otherwise, what are the privileges that they exercise is almost the same. Yes, there are few differences that I'll also discuss. But before I get into this, you'll have to basically understand as to what is a privilege. Basically, it is, I'm going to repeat the same concept because it is the same as I discussed in the parliament chapter. Now basically what is a privilege? So privilege are special rights and entitlements that are given to the members of the state legislature under article 194. Why these special rights and entitlements are given to them? Because these special rights and entitlements would help them to perform their duties effectively. And what is one of the important duties of the members of the state legislature is to question the government and to make the government accountable. And to question the government, to criticize the government, therefore to make the government accountable, they should have the right to freedom of speech in the legislature. So the right to freedom of speech is guaranteed under article 194 of the constitution. Is that the only privilege that is given to them? That is not the only privilege. Apart from the right to freedom of speech, they also have the right to vote. And the constitution says for which they are not liable to be prosecuted in a court of law. They are not liable for any prosecution in a court of law for whatever speech they have made and vote that they have given in the houses of the state legislature. But however, this is subject to the rules of the house, and this is subject to the other provisions in the constitution. When I say they have the right to freedom of speech, it doesn't mean that they can speak whatever they want. It is not that they can use unparliamentary languages when they speak in the state legislature. That is subject to the rules of the house. The rules may restrict as to what they can talk and what they should not talk, how they should talk, when they should talk. All these things can be regulated. And it is also subject to the other provisions of the constitution, which also means not just because they have the parliamentary privileges under Article 194, the members of the state legislature can engage in what is called as the contempt of the court. That means the members of the state legislature cannot discuss about the conduct of the judges and criticize the judges. So therefore, the right to freedom of speech, which is although their privilege, it is not absolute in character. Now apart from this right to freedom of speech, they also have what is called as right to publication. Right to publication means it is a right of the members of the state legislature to publish the proceedings that happens in the houses of the state legislature. They can publish the proceedings and the contents that has been discussed to the outside world. That is part of their privilege. So this right to freedom, right to publish also includes what is called as right to expunge. Right to publish means while they can have records of whatever has been discussed, and these records may be made accessible to the outside world. Right to expunge means they also have the right to let out something that has happened in the parliament or in the state legislature to be part of the official records. That means when I say right to expunge is there, not everything that is spoken in the legislative assembly or the legislative council will be part of the official records. And who has the right to expunge? It is a presiding officer who will have the right to expunge on behalf of the house. So the presiding officer thinks if certain things that is spoken in the house, although they have spoken it because it is their privilege, but the presiding officer feels that there is no basis of reality and it amounts to an unnecessary criticism of the government, or there are certain things which is not appropriate. So therefore those things can be expunged by the presiding officers. So therefore what are the privileges that is given to them? Right to freedom of speech and the right to publication, which also includes the right to expunge what has been spoken and discussed in the state legislature. These two things are explicitly given in the constitution under Article 194. But apart from that, the constitution also says, apart from these two privileges, if any of the other privileges are to be given to the members of the parliament, in this case the members of the state legislature. So apart from these two privileges given in Article 194, if any of the other privileges are to be conferred to the members of the state legislature, then the particular state legislature can make a law, and by that law they can confer the privileges. So therefore try to understand what the constitution is saying. The constitution is giving some privileges, but apart from that, if there is a need to provide any of the other privileges, then who shall provide that? The state legislature may make a law, and by that law they can confer the privileges. So this is what the constitution is saying. But however, no such law has been made by any of the state legislature. So therefore, keeping this in mind, the constitution also says, till the time such a law is made by the state legislature, the members of the state legislature can continue to exercise such privileges as it existed before the commencement of the constitution. Before the commencement of the constitution, the members of the provincial legislature at that point of time, they had a number of privileges based on parliamentary conventional practices that they borrowed from the British parliamentary system. So whatever privileges that they exercised before the commencement of the constitution, all those privileges they can continue to exercise. So therefore overall, how do you understand as to what are the parliamentary privileges? Whatever is mentioned in Article 194, that is right to freedom of speech and the right to publication, which includes the right to expunge. Apart from that, the state legislature can make a law and confer more privileges upon the members of the state legislature. In the absence of such a law, they can continue to exercise such privileges which were exercised earlier in the form of what is called as parliamentary conventions. So today, if you ask me what is the source of parliamentary privileges to the members of the state legislature, there are two sources. One is whatever is there in the constitution, Article 194, and other is in the form of parliamentary conventional practices. This is basically what you'll have to understand. But however, what has happened over a period of time, that the way these privileges were exercised by the members of the parliament had come in conflict with the rights exercised by the people. There are two important cases to understand this as to how it has come in conflict with the rights exercised by the people. One such important case is the M.S.M. Sharma case, and other is the Keshav Singh case. Once you will understand these cases, it will also be quite clear as to how a parliamentary privilege can come in conflict with the fundamental rights. In 1959, in a case which is called as M.S.M. Sharma case, this happened in the Bihar Legislative Assembly. In the Bihar Legislative Assembly, there were some proceedings, and whatever discussion that has happened in the proceedings, the presiding officer has expunged it because it is part of the right to publication. But despite expunging certain content, it was published in a news article or in a media, which came to be called as M.S.M. Sharma case. M.S.M. Sharma was an editor of a magazine called as Searchlight. Despite certain contents which has been expunged during the proceedings, but however, M.S.M. Sharma has published all those things. So therefore, the Bihar Legislative Assembly thought by the M.S.M. Sharma, by doing this, he has engaged in the breach of the parliamentary privilege, that he has gone against the privilege of the parliamentarians, that is the members of state legislature here. So therefore, M.S.M. Sharma was summoned and was to be questioned by the Bihar Legislative Assembly. But in the meantime, M.S.M. Sharma has gone to the court and he has put in front of the court all that he has done is exercised his right to freedom of speech and expression under Article 19. He has not done anything apart from that. So therefore, the court has to find, or the court has to pronounce that what is supposed to be happen if there is a conflict between the parliamentary privileges and the right to freedom of speech and expression, or for that matter, any of the other fundamental rights. Now, in this case, the Supreme Court came to a conclusion that when there is a conflict between the parliamentary privileges and the fundamental rights, the parliamentary privileges will be given precedence, or the parliamentary privileges will prevail, as the fundamental rights are subject to the parliamentary privileges in a parliamentary democracy. Therefore, the parliamentary privileges were given more importance. But however, in the next case, which is also called as the Keshav Singh case, in the Keshav Singh case, the same matter came in front of the Supreme Court. In fact, I have explained the entire case in detail in the Parliament chapter, where I have discussed about the parliamentary privileges. So you can go and look into the details of the case there. Very interesting and a very, very interesting case, I would say, because this is a case where two important organs came to conflict, that is the legislature and the judiciary. So therefore, the Keshav Singh case becomes very important, but let me just discuss the judgment in this particular case. So what happened in the Keshav Singh case? In the Keshav Singh case, the Supreme Court said, if there is a conflict between the fundamental rights and the fundamental rights and the parliamentary privileges, especially when it comes to the fundamental rights like right to life and liberty, what will be given precedence is the fundamental rights will be given precedence over the parliamentary privileges. So therefore, the parliamentary privileges cannot be exercised in such a way that it would violate the right to life and liberty of an individual. So therefore, whenever the parliamentary privilege is exercised by the parliament or the state legislature, they should not violate the right to life and liberty, and if it is done, then that is subject to what is called as judicial review. So this has been what has been held by the Supreme Court in this particular case. So two cases are very important. If you know the answer, can anyone tell me that under which article of the Constitution the President has made a reference to the Supreme Court related to the Keshav Singh case? In fact, it was not a direct case. The President made a reference to the Supreme Court of India to give opinion on this particular case, because the case was a very complex case. And I discussed the entire case in the previous lecture, not in the previous lecture, but when I was discussing about the Parliament, where I was discussed about the parliamentary privileges, because this led to the conflict of the legislature and the judiciary. And this is what you should understand with regard to the parliamentary privileges. In fact, from the mains point of view also, I have discussed it there, so you can go and refer it there. From the mains point of view also, I discussed that is there a need to codify the parliamentary privileges. So I have given reasons also there, you can just listen there with regard to this also. With that, we are coming to the end of the discussion in this particular lecture. So just go through this particular question, and with the question we are almost done. Consider the following statements. Statement 1. The number of sessions in a given year in the state legislature is determined by the law passed by the concerned state legislature. Is it determined by the law passed by the concerned state legislature? See whether it is right or wrong. Statement 2. All bills pending in the Legislative Council not passed by the Assembly will lapse on dissolution of the Assembly. So try to understand under what circumstances the bill will lapse, under what circumstances the bill will not lapse. Which of the statements given above are correct? So 1 only, 2 only, both 1 and 2, neither 1 nor 2. You can put the correct answer in the comment box. So with that, we are coming to the end of this particular discussion. If you like this video, please share it with your friends as well as family members. I'm putting an immense effort behind this particular series. So therefore, it is going to help, I know, the millions of students in the future. So please do support by sharing this particular video to the students who may be preparing for the examination. Thank you very much. All the very best.